Bryan Kohberger, come on in. Come on in. Get yourself a cup of coffee. We are going to watch a hearing that's going on, that went on just a little bit ago. So you're going to see it here first on this channel. Got the hearing, and this is going to be about
web creation platform built for agencies.
Oh, I had the volume. Got to turn the volume down. So we're going to hear a hearing today. It's over IGG. It's a conference. It's about 30 minutes. Let's rock and roll. Let's watch this bad boy right here and see what happens. I already know the outcome and I already put out the outcome, but we're all going to watch this in real time right now. Check it out.
It appears that way. So let's get the record. This is State of Idaho versus Bryan Kohberger, case number CR 2805. We're conducting this status conference over Zoom. There are people in the courtroom, but all counsel are participating on Zoom. Representing the state is Ms. Jennings, Mr. Thompson, Mr. Nye, and Ms. Beatty. Representing Mr. Kohberger is Ms. Taylor, Ms. Massa, and I don't see Mr. Logston is also on Zoom. Is that right, Ms. Taylor?
Your Honor, he is. We're in the same room. You can't see him, but you can hear him. And I'm downstairs right now.
Okay, thank you. All right, so this is a status conference following the court's order addressing IGG DNA and an order for in-camera review. And when we were talking about this at the last hearing, the state wanted to sort of find out how quickly they could get some of this IG. So start with you, Mr. Thompson.
Thank you, Your Honor. We met via Zoom or Teams or with the folks from the FBI on Monday, and we had shared with them already a copy of Your Honor's order, and we have now sent a 2E letter, which is the formal request process we have to go through. They indicated that they would try to see if it could be expedited. The 2E letter has to go all the way back to Department of Justice and route through its bureaucracy. We asked for, give us an estimation, and they said, well, it could take as long as a month. And so that's where we are right now. We're already in the process of making sure we've gathered everything from the private contract DNA company, so we'll have that ready to submit along with what we receive from the FBI once we get it.
Okay, and has it been specified in terms of what kinds of information they have and may be willing to provide?
We gave them a copy of Your Honor's order and said, and the 2E letter says, please provide all information that the court's direct in the attached order.
Okay, thank you, Mr. Thompson. Let me go now to Ms. Taylor.
Thank you, Judge. Your Honor, if I'm understanding Mr. Thompson correctly, the court should receive information from Optum Labs for the work that they did, probably ahead of the work that the FBI did. If reading between the lines, that's the private lab, and I think the state has more ready access to all of the Optum lab work and filings. So I guess where I'm at is I would still ask the court to set deadlines for each, and if they're to come in separate pairs or separate sets of information, that's okay. But I think the court could set deadlines for the Optum materials as well as the FBI materials, understanding that Mr. Thompson estimates at least 30 days. you have some additional questions and requests for that process when the time's right.
Okay, thank you, Ms.
Your
Taylor.
Honor, if
Go, yeah, I was going to go back to you, Mr. Thompson. Go ahead.
I think that it could be misleading to the court to only have partial information to work with, and it'd be our preference that we make a complete submission all at once. Because Your Honor can't assess all of what's out there without seeing all of what's out there and seeing the interrelationship between it.
All right. Because the lab and the FBI were sort of working together, is that what?
No, I think, as Mr. Nye described in his briefing on this, the work began with the private lab, and then there was a transfer to the private lab, from the private lab to the FBI, and there were also reports the private lab prepared, preliminary reports that were sent to the Idaho State Police Laboratory, and they all address the same things and overlap. And so it would be, from our perspective, because we've been trying to sort through this ourselves, we're inviting confusion for the court if you don't have everything in front of you, if you're just trying to look at this piecemeal. I mean, we're happy to give it to you however Your Honor wants. It's just a heads up that your review before having everything is not going to be particularly productive.
All right. You want to respond to that, Ms. Taylor?
I do. Thank you. Your Honor, I would not expect the court to make decisions about Othram without having the full scope. It's just been a long road for us to get information. The court is aware after our third motion to compel and the state's response that we were going to get SNP profiles, and I know that the state waited until they had the FBI profiles available to give us the SNP from Othram. Your Honor, we will have further discussions later about that, but I think that there's missing information from the Othram profile that we have. I'm hoping the court gets it, and I certainly understand that the court needs to see everything to make a decision. My hope is that everything includes communication so that you can follow the path of what happened while you make your decision as well. I wouldn't expect you to release it or decide what portions would be released or what orders might apply until you see it all. I'm hoping that there will be some deadlines in place so that you can begin getting the information.
All right, thank you. My understanding is that that the private lab SNP profile was already provided to you. Is that right, Ms. Taylor?
Your Honor, I received in discovery a SNP profile, SNP profile that I believe came from Othram and one that came from the FBI. The Othram is not the FASTQ file, which is the general format that those come out in. It's a different kind of file, and it's a smaller data file than the FBI data file. And so I think that there's some issues with what we received from Othram. We have that. We have what the FBI file is, although it's missing a good percentage of information, and we'll be talking to the state about some of that later, but they've provided some things. We think it's sufficient though.
Okay. Obviously, I'm asking to look at all this because I can't make informed decisions if I don't. Is my understanding was maybe there was one SNP profile, but now I'm hearing that maybe there are two, one from the FBI and one from the private lab?
That's correct, Your Honor. And the difference is the one from the private lab is the initial profile that the private lab analyst created from the DNA, the portion of the DNA sample.
Right.
Then what was transferred to the FBI was after that original SNP had been uploaded to a database, access to the database was transferred. And it's our understanding that once a SNP is put into one of these databases, the database adjusts the SNP to fit what their criteria are for them to do their searches. So there are differences between the two, the entirety of the two SNPs. Mr. Nye, you're very knowledgeable on this. Jump in if I'm not stating it clearly. And so in an exercise of caution, we wanted to make sure the defense had both. Had what the original SNP that the private lab created, and also the SNP that was transferred via the transfer in the database to the FBI. We wanted to make sure that we weren't overlooking anything, and the FBI saw, or the defense saw both of them. And we are told, we understand that, like I just said, the databases adopt the SNPs to their search components, and so they're going to look slightly different.
Okay, thank you. Do you want to add anything to that, Mr. Nye?
No, Your Honor, I thought that was very well said.
Okay, thank you. Well, we're all learning a lot about DNA, that's for sure. So, you know, I don't know that I have the capacity to really examine the information piecemeal. I would prefer to just look at it all at the same time because, I mean, maybe there are comparatives here, obviously. So what I'm going to do, and I know that, I mean, this is complicated too, and we've heard this already, just getting complete information from FBI, but apparently it's in process. I'm going to set a deadline for all the information to be provided to the court by December 1st. That should be sufficient time. If something comes up between now and then, I'm sure I'll hear from some of you or all of you. We can have another status conference if necessary. But I would really just want to push this out, or not out, but more quickly as possible, so that we can get to a lot of the issues that we really have to address as well. So, not that this isn't important. All right, so I think that's really all we need to address today, unless anybody else has some other issues. Mr. Thompson?
No, sir, and I will communicate that deadline to our contacts with the FBI today and let them know if there's going to be some delay. We need to hear about it sooner than later, and we need to have a good explanation for it.
Okay, excellent, thank you. Anything else, Ms. Taylor?
Yes, Your Honor, two things. Your Honor, I am going to request that the court make a privilege log of what the court receives in this packet of information the court's going to review. I will want that to be released to me to make sure the court has a full packet of information to review in making its decision. The other area that I want to talk about is what does in-camera mean? This is really complicated, and I would like to know how the court is going to learn about these things. If the court has to consult with anybody, I want to make sure that there's not going to be an FBI agent in the room with the court or anything like that to try to do the in-camera review to make heads or tails of what this stuff means.
Well, that's a good question. I don't know the answer to that. A lot of what I'm reading and learning from is all the information that both sides have submitted to me, or telling me in these hearings. So that's I'm not pulling information from outside of that, because that's not on the record. I suppose if I have to bring somebody in to help me understand this, you will know that. Both sides will know that. Another way to look at this is I could have another hearing, and you all can help me understand this if that's necessary. I think I have a fundamental understanding about all of this, and that's, I think, expressed in the order. But I understand this is complicated stuff and it's somewhat controversial. So I will do my best. That's the best I can do. All right. Anything else then?
Your Honor, I'm not sure what counsel means by a privilege log. It seems to me to defeat the purpose of the in-camera review if the court tells the defense everything that it received. I mean, that seems contrary. So I don't know what's being contemplated there. We are going to give you everything we get. And if the court has questions, the court can ask those questions however it feels it needs to. If the court wants to bring in outside help to understand in the way of an expert or something, we don't have a problem with that. We want the court to be able to make an independent decision on this, taking into account and considering the concerns that we have expressed through our briefing and argument, and understanding the court's interest in ensuring the defense has access to what it legally would be entitled to, and that appropriate protections are put in place on sensitive or personal or private information as the court deems appropriate, so that third parties are not injured by what is occurring.
Okay, thank you, Mr. Thompson. I interpreted that as that the state needs to document everything that they're getting just in case, so that if there is an issue down the line, that is documented. That doesn't necessarily mean that you turn that over to the defense automatically. So I don't know if Ms. Taylor suggested that you provide all that information to Ms. Taylor before I make a decision in camera. You want to clarify that, Ms. Taylor?
Yes, thank you. Your Honor, what I am hoping that the court will do is just create a list or a log of what the court receives, not the detail of the content, but things like the raw data snip file from the communications between Othram and the FBI, not the content, just that you have those. The statistical analysis that happened within the profiles when making decisions, when the genealogist made decisions about the family tree, you have the statistical analysis, that you have the bioinformatics or the microarray, that you have access to those things. That's it. That's what I'm thinking that the court would do, is make a list of those kinds of things received. The court should also include that the FBI complied with the requirements in my family tree. Those kinds of things, not copies of them. That's what the court's looking at in camera and making decisions for. And I certainly understand the need for information to be protected. During the course of this case, I've signed orders agreeing things are held in a protected way so they're not used without further order of the court. I certainly understand that need, and that's one of the things that I think the court may get to with this. But the privilege log isn't the content, just a list of the things that you've been able to review to make a decision about.
All right. Well, that may happen. I'm not. It's hard for me to make decisions in the abstract. So, I'm going to see what I receive, what I get, and then I'm sure that the state is going to document all of that, and then I'll make a decision about what is disclosed. I mean, that's the reason for the in-camera review. But I do think that it's appropriate for you to understand exactly what was provided, even if you might not get to see it. But I just don't know what that is. So I'm not gonna, bind myself yet. Okay, until I see what I get and when I get it. And that goes with, if I need to bring somebody in to, an independent DNA scientist, then, you all will we'll get to know that. But I'm assuming that you are all very educated about this already, so maybe I don't need to do that. We'll see, all right? But if this can be provided sooner than December 1, that would be fantastic.
Yes, sir, and that would be our intention. As soon as we have everything that is out there, it's our intention to put it together and submit it to the court and have kind of a list of table of contents or index, whatever you want to call it, of everything that's being provided to the court. I will say, listening to Ms. Taylor's recitation of all sorts of specific types of stuff, that based on our understanding, there are items that she thinks ought to be there that do not exist in the way of documentation, form, in any fashion. We will give you everything that we are provided with, and we have asked for everything that exists, both from the private lab and from the FBI, and that's our intention. But I don't think that the lawyers ought to get into this guessing game of what should and shouldn't be there, particularly since it is our position defense has a fundamental misunderstanding of the difference between SNP profiles and traditional DNA comparisons and how that process works. When we start talking with statistics and those sorts of things, those don't necessarily apply in the investigative genealogy world. So I don't want there to be false expectations, and I certainly don't want the court to be misled that things of relevance exist that do not.
Well, I understand that issue to some degree because I've been reading your briefs back and forth. So I understand that that is a repeated kind of issue, and I think, excuse me if I'm wrong about this, Ms. Taylor, but they want to be able to see what has not been documented. So that's one of the issues that there's going to be a struggle about, and I understand that the process, the procedures of some of these IGG procedures are not documented. You know, there might be some notes. I understand that the FBI has some notes. So let's start where we know we have things, and then we can go from there.
Yes, sir. And that's how we prefer to proceed. I was just reacting to the laundry list of things that Ms. Taylor was reciting that, based on what our experts have told us, don't necessarily exist in an investigative genealogy SNP analysis. That they may exist in a traditional STR DNA analysis. And those are two separate and distinct processes. They do not overlap at all. So we want to make sure that there's no confusion, because some of the things that have been submitted by the defense don't accurately talk about the distinction. And that's why Mr. Nye, in our filings, submitted the affidavit from Ms. Nowlin at the Idaho State Lab, talking about the distinction, the difference between two separate approaches to DNA. I just don't want to muddy the waters. I don't want there to be false expectations created.
I
We
understand.
provide, as always, everything that we get, everything that we can find, everything that's provided to us, we will provide to the court for its review.
Thank you. And I understand it. They're very different. Okay? I mean, I think that's really clear in the order addressing IGG DNA. I also understand that the state and the defense have different lists. So I will look at it, and I'll muddle through it as best I can, and but I do understand the difference, and the reason why IGG DNA profiles aren't the same, okay, as our more traditional DNA profiles that law enforcement use and courts have been used for years.
Thank you.
Yeah. All right.
Your Honor, may I respond?
Sure.
I want to respond to the accusations that we're misleading the court and that we're trying to muddy the waters.
I didn't take it that way.
This is about the third time that these kind of pokes are happening at the defense, and we haven't responded to it. And Your Honor, I just want to respond that the information that I talked to you about, this laundry list, as Mr. Thompson says, a lot of that comes from expectations based on reading Department of Justice policy that was included for the court with our briefing before the August 18th hearing.
Right.
A lot of that information comes from the testimony of the two genetic genealogist experts that we put on and the information that they provided to the court at the hearing. These aren't made up things. We absolutely understand that the genetic genealogy investigative process is different than what the Idaho State Police Lab does with STR violence. But there's analysis that happens along the way in building out these family trees to identify somebody. That was talked about in depth. We are not trying to mislead the court. We have been absolutely clear, and we've relied on Department of Justice policy in our expectations. So I just wanted to make a record of that.
Okay.
Your Honor, I'm not suggesting that they were intentionally trying to mislead the court. It's our position that they have been provided with information that's not accurate and it's creating false expectations, and I don't want the court to be misled by that and to have expectations that are not accurate. That's all.
Okay. Thank you both. And I really try hard not to get misleading information and then rely on it. So I will be very careful about this. This is really important, and it is, well, as I said in the order, this is a first impression in Idaho, and I want to make sure that we do it right the first time. That is exactly why I requested some information, the IGG DNA information, so that I could go through that and understand it better and make an informed decision for what should go to the defense and what maybe shouldn't. I can't make a decision about that yet. So, but I appreciate the separate positions that you both have, and we'll, like I said, do our best. So if something comes up between now and December 1st, as I said, you can ask for another scheduling conference or a status conference like this so that we can kind of iron out the wrinkles if there are any. Particularly if we find out from FBI that it's going to be, much longer period of time before we get it. Now, I sure hope that doesn't happen. So we'll see. It sounds like they're working at it. So that's reassuring to some degree.
I will be speaking with them this afternoon, Your Honor, to let them know and impress on them. I think they understand that this is time sensitive and we would like to see it happen sooner than not. My impression is they did not want to underestimate what the amount of time might be, and that's why we're looking at an initial ETA of up to a month.
Okay, great. All right. With that, anything else?
No, sir.
Okay. Ms. Taylor?
No, Your Honor, thank you.
Okay, well, thank you all, and hope you have a nice rest of your week and nice weekend. Thank you. Take care, everybody.
Thank you, Your Honor.
Okay, we are adjourned.
Here first. Okay, everyone, you heard it here first. JLR investigates. Got the hearing out for you as soon as possible. What's your thoughts? What's your thoughts on the situation? It's a battle over who gets what of this IGG. Some things that were confirmed today that I, wasn't really put on the record like that. Optum, the private lab, Optum, handling it. Now, prosecution says the FBI, the DOJ has a lot of this stuff and they have to get it from them. Said it could take a while. But the judge set up a December 1st deadline, which he said could be extended. Also said, hey, if you guys want to come in beforehand and for another conference status hearing, we'll iron things out if there is anything that needs to be ironed out. Ann Taylor in the basement below that courthouse, she's below with Bryan Kohberger with the glasses, kind of look futuristic there. Thompson in his own office. Saw Jeff Nye in his office. All of them look like they were all in different locations. Nobody in the courtroom as far as participants in this case. It was open today for spectators and media. To summarize a little bit, there has been the Idaho Statesman has put out an article, and I just want to read this real quickly for you to kind of summarize what was said and what transpired today in this courtroom. The DNA records that first identified Bryan Kohberger as the suspect in the University of Idaho student homicides must be delivered to the court by the beginning of next month. The judge overseeing the capital murder case ruled at a hearing Thursday. Judge John Judge of Idaho's 2nd Judicial District set a deadline for December 1st for prosecutors in the case to retrieve and submit the records from the FBI, some of which he had already initially ruled must be turned over to Kohberger's defense through the legal process known as discovery. Judge plans to review the documents behind closed doors before issuing a final decision on what information may be kept from the defense, including through a protective order requested by the prosecution. With just 3 days of advance notice, Judge scheduled the hearing to provide an update on the records related to an advanced DNA technique used by police called investigative genetic genealogy, IGG, which the FBI employed to land on Kohberger. The technique involves taking DNA from a crime scene and submitting it to an online genealogy service such as 23andMe and Ancestry.com to build a family tree to locate the suspect. Defense and prosecuting attorneys attended virtually on Zoom, which you guys just watched, which everyone just watched, for the likely attended hearing at the Lake Tahoe County Courthouse. Speaking on behalf of the prosecution was Bill Thompson, the one with the beard. We're familiar with Bill Thompson. Speaking on behalf of Kohberger was his public defender, Ann Taylor, appearing from a jail located in the courthouse's basement alongside Kohberger, who was off screen and not shown. We didn't get to see Kohberger's face. That would have been kind of cool to see Kohberger's face, by the way, head on, instead on. Taylor asked for an inventory of FBI records be produced, as well as for clarity from Judge about the closed-door review process. He said during the roughly 30-minute hearing, we watched this thing for 30 minutes, folks, that he may schedule a future hearing with an expert on the issue to ensure he conducts it properly. I'll do my best. That's the best I can do, Judge said. He'll do his best. The prosecution and defense have been battling over the disputed records since May. So June, July, August, September, October, 6 months, folks. When the defense filed its first discovery request specifying citing IGG records and DNA profiles uploaded to databases. In June, the prosecution disclosed for the first time that the FBI used IGG to land on Kohberger as a suspect in its request for a court protective order of the information. The prosecution said the FBI, which was almost immediately brought into the homicide investigation, passed along a tip to investigate to local law enforcement after obtained the IGG results. However, in a court filings opposing the release of the records to the defense, as well as at the hearing in August, the prosecution affirmed that the IGG results were never used to secure any warrants related to Mr. Kohberger, including for his arrest. Thompson told Judge that he spoke with an FBI in a virtual meeting on Monday to submit his formal request for all of its IGG records related to Kohberger. I would love to be a fly on that wall, right? Thompson speaking to FBI just a couple days ago on Monday. It's according to what Thompson said. The request could take up a month to fulfill, he said to the agency. The agency told him. For his closed-door review, Judge said he would like to look at all of the records at the same time. Likewise, Thompson stated his preference that none of the records requested by the defense be turned over until they're all in hand, but will meet whatever the court demands. So if the court says otherwise, Thompson wants it all in one batch to Kohberger's defense, or for the court to see. And then just the judge will decide what goes over to the defense, if at all. But according to the latest filing on the record, Kohberger's defense is entitled to some of it. Some of it. What that will be, I don't know. It's up to the judge. Othram confirmed that's private lab in Kohberger case. Prosecutors don't plan to introduce the IGG information at trial, Thompson wrote in a June legal filing. Instead, they plan to present the statistical match between the DNA found at the crime scene and a cheek swab law enforcement took from Kohberger after they took him into custody. Looks like that happened January 5th, by the way. The state's argument that the IGG is wholly irrelevant since it was not used in obtaining any warrants and will not be used at trial is well supported, Judge wrote in his ruling last week. Nonetheless, Kohberger is entitled to view at least some of the IGG information in preparing his defense, even if it may ultimately be found irrelevant. Kohberger is charged with 4 counts of first-degree murder and 1 count of felony burglary in the stabbing deaths of 4 Idaho students. The anniversary is coming up next week, soon, 11 more days. So it's all over, you know, the DNA on the night sheet. So there you go. What's your thoughts? It looked like Thompson and Taylor were going kind of at it a little bit at the end. It was kind of getting juicy. Interesting, right? A little popcorn stuff. Now, what will be turned over? Do you think the prosecution should turn over all the list of Kohberger's family members up to the 50th degree? Lots and lots of them, because the prosecution kind of implied that they were informants. And you know what was interesting about this whole thing? The judge saying, we are learning a lot here about DNA. As if the judge didn't even know about this prior. Like, this is all new to him, too. I think it's new according to Idaho court rules. It could definitely set precedent whether IGG, which I feel is now in the future, it's actually now. But we'll say IGG is the future in solving cases. It's really not, at this time, sketched in as discoverable under Idaho court rule. Will the judge rule in favor, of Kohberger's defense to release some of this stuff to the defense? And if so, future cases could be affected by this. If he says no, future cases will be, set. It will affect future cases where defendants can't get that information. Wild stuff, folks. I think I explained this the best I could in this situation. I'm reading your comments. They're coming through lightning speed, folks. Your comments are coming through lightning speed. Let me know your opinion on this. What's going to happen here? Now, the question is, the FBI, what happens if they stall? What happens if they, under their own policy, rules, and procedure, though Ann Taylor said they have their policy, what about if it's different jurisdictions working or different agencies working, hand in hand? What happens if the FBI decides not to give that stuff up to Lake Tahoe County prosecutors? Is Lake Tahoe County prosecutors at fault here? Because at the end of the day, they claim they're not even going to use this stuff at trial. But what if the FBI doesn't release? What about the Lake Tahoe County prosecutor says to the judge on December 1st, we tried and the FBI is not releasing this, that, and the other, and Ann Taylor's insisting it. What does this do with the Bryan Kohberger case? Does it stall it? Does it deprive Bryan Kohberger the right to a fair trial? It's interesting stuff. We're in this uncertainty here. We're in this uncharted territory, I think, that's going on. But I don't think we're going to hear the end of this. I think they're going to have another one. Inadmissible. I see a comment, inadmissible, but the prosecution's not even bringing this up anyway. So it's like, wow. We're in that wow moment, folks, in real time. It's a fascinating process to go through. We'll ultimately see what happens. Judges like, have a great rest of the week, as if there's going to be no more hearings. But this one just popped up. This one just popped up a couple days ago. It actually popped up on Halloween. Short notice. But we appreciate some of the journalists. Like I've already made a report. I was watching Brian Enton, News Nation. He was in the courtroom. That guy was there, man. So, you know, quick hearing. I think it's important. My position on this case, like it matters. It really doesn't, but I'm just telling you my position. Open it up. But at the same time, does law enforcement or does the defense get the right to have identities of people, lab people that handled that IGG stuff? And I'm not so sure about that. Should investigated techniques be released to the defense? I'm not so sure about that. So there's going to be, I think what Judge is going to do is some sort of balance with this situation, right? He's going to weigh the pros and cons, and I believe he's going to come with a middle ground, but favorable towards the prosecution. But again, give some stuff. Maybe it's not even irrelevant. Maybe it's garbage stuff to the defense for them to have. Is this stuff enough to get Bryan Kohberger off? I don't know. What do you think? Do you think it won't be relevant at all? It's mind-boggling. But we're covering this case extensively. Anytime there's a hearing, we'll get the footage, we'll share, and we'll keep paying attention. We'll keep paying attention to this. This could be dragged out. This could definitely be appealable before the trial even starts. This could make its way up the appeals courts. It's definitely the DNA. I don't necessarily know about the IGG, but the DNA is a big part of this case. It's the most direct evidence of this case. So this is part of it. I think it goes hand in hand, and I think it all works together here. So that's the situation. Yeah, I'm animated. Thank you. But you heard it here first. JLR investigates. If you're new to the channel, welcome. Covering this case extensively. The anniversary is coming up. We pray for the victims' families. We pray for the community of Moscow. What's going to happen here, people? What's going to happen? I thank you for watching. Hit that like button. Share this video. And we will talk soon. I will keep coming with videos. JLR making sense out of this. I mean, the best I see it. If you guys see it otherwise, please comment. Please comment if you feel it's going a different direction or a different way or however your take. We want to hear your take on this channel. Shoot the comments so everyone can see your take of what you think is going to happen with this situation. I appreciate all of you. And I love the different perspectives too. This is, you heard my position. I respect your positions for sure. Thanks for watching, everyone. I'm signing off. JLR Investigates. We'll talk soon. Stay tuned.